my previous talk, I discussed the 19th century precedents in the struggle for women's rights. In this talk, I will examine a few more recent cases that created the foundation for constitutional claims of sex discrimination. In the century between Bradwell versus Illinois, in which the Supreme Court upheld discrimination on the basis of sex, and Frontiero versus Richardson, the case I'll discuss in this talk, it is clear from the facts that a great deal changed for women. The plaintiff in the Frontiero case, Sharon Frontiero, had many of the rights that Myra Bradwell did not. For one, she could vote. She was also an officer in the military, something that 19th century women's rights activists could scarcely imagine. Sharon Frontiero was a lieutenant in the Air Force, and her case emerged from her efforts to secure benefits for her and her husband. As a policy, the Air Force offered financial support for members' families, including housing allowances and medical and dental benefits. For servicemen, these benefits were distributed automatically. But women had to prove that their husbands were in fact dependent on them financially in order to qualify. This administrative policy served as a matter of convenience to the military. It assumed that wives were less likely to work, and therefore they were probably dependent on their husbands. The same thinking, that men belonged in the workplace and women belonged at home, applied to the policy towards service women. Their husbands were more likely to work and therefore less likely to be dependent. And so in the early 1970s, women like Sharon Frontiero were tasked with proving that they were the primary breadwinners in the family. Before the Frontiero decision, states in the federal government routinely preferred men over women as a matter of policy and law. Until the 1964 Civil Rights Act, it was legal for businesses to discriminate against women in hiring, and banks could refuse to allow women to open accounts or take out loans without their husbands as co-signers. The first Supreme Court case that indicated that the federal courts might be willing to question the legitimacy of sex discrimination came 2 years before Frontiero, in 1971. This was a case in which Sally Reed appealed the decision of an Idaho court to give her estranged husband, Cecil, I'm not sure, primary control over their deceased son's estate. Their son died young and without a will, so he died intestate. And Idaho law gave preference to fathers over mothers when determining who should settle the affairs of a state, or of a deceased child. The couple was separated, and their son lived with Sally, and so she felt that she should control his estate. The Idaho Supreme Court determined that the law was a fair way to avoid disputes among opposing relatives, and so they said the law did not discriminate unconstitutionally against Sally Reed. The courts determined that this kind of discrimination was benign and therefore posed no problems. Sally Reed and Sharon Frontiero both found assistance from the American Civil Liberties Union, which had formed a women's rights project a few years earlier. Ruth Bader Ginsburg headed the project, and she argued both cases before the United States Supreme Court. In Reed versus Reed, Ginsburg successfully argued that convenience was not a defense for this kind of sex discrimination. The Supreme Court agreed with Ginsburg and declared that the Idaho law was discriminatory. The Reed decision was an important landmark in the struggle for women's rights. For the first time, the Supreme Court acknowledged that sex discrimination was problematic and might violate the Equal Protection Clause of the 14th Amendment. It was not clear, however, what kinds of sex discrimination might still be legal. The Reed decision did not say that all sex discrimination was unconstitutional, just that a law that discriminated for administrative convenience and essentially to reduce the workload of probate courts was not constitutional. Until Reed, states in the federal government only had to prove that laws that discriminated on the basis of sex had what's called a rational basis. In other words, they needed only to prove that they had a reason for laws that discriminated on the basis of sex, and that the laws were not arbitrary. This was a pretty low bar, and so it effectively permitted legal discrimination against women. Reed implied that old rationales about the inherent inequality of the sexes could not necessarily be used to justify discrimination. It didn't meet the rational basis test. In the Frontiero case, Ginsburg wanted to capitalize on this shift. More than that, Ginsburg and the ACLU hoped to convince the Supreme Court to declare gender a suspect class. This would raise the bar and increase the evidence necessary to prove the constitutionality of laws that discriminated on the basis of sex. Suspect classification would mean that all such laws would be subject to strict scrutiny, which is the highest level of judicial review. In order to pass strict scrutiny, the government would have to prove that a law served a compelling government interest, that the law was narrowly tailored to achieve that interest, and that it used the least restrictive means in its operation. Compare this to rational basis, and you can see the appeal of suspect classification. Whereas rational basis just requires a reason, strict scrutiny requires a great deal of evidence in order to prove that discrimination is not unlawful. And so, strict scrutiny is sometimes called strict in theory and fatal in fact. Race, national origin, and alienage, so immigration status, had been categorized as suspect classes since the 1940s, and Ginsburg and other women's rights activists sought to prove that the laws that discriminated against women were just as pernicious as other kinds of discrimination, like that on the basis of race or nationality. These levels of scrutiny can be confusing, especially for my students when they take tests, but they can be tremendously useful to groups that have a history of discrimination. Strict scrutiny emerged from the internment of Japanese Americans during World War II, and if it applied to women, it would have entirely dismantled coverture and its legacy, which prevented women from having the same rights and responsibilities as men. Making women a suspect class 2 would have avoided the need for an Equal Rights Amendment, which would have achieved largely the same effect. The Equal Rights Amendment was first introduced into Congress in 1923. It struggled ever since, making the courts an appealing option for Ginsburg and the Women's Rights Project. So in 1973, when the Supreme Court ruled on Sharon Frontiero's case, it actually looked as if the Equal Rights Amendment might be ratified by the states. Congress overwhelmingly voted to pass the amendment in 1972, and before the Supreme Court announced its decision in Frontiero versus Richardson, 30 states had already voted to ratify the amendment. Momentum seemed to be on the side of women's rights activists. It appeared for the moment as if sex discrimination might be deemed unconstitutional through ratification, court decree, or both. Sharon Frontiero won her case. The Supreme Court declared that, as in Reed versus Reed, sex discrimination for the sake of administrative convenience violated the Equal Protection Clause. The plurality opinion, written by Justice Brennan, acknowledged that women faced a long history of legalized discrimination and that they faced particular challenges. The plurality decision declared, quote, "There can be no doubt that our nation has had a long and unfortunate history of sex discrimination. Traditionally, such discrimination was rationalized by an attitude of romantic paternalism, which in practical effect put women not on a pedestal, but in a cage." Ruth Bader Ginsburg wrote that. That was in the brief. Indeed, this paternalistic attitude became so firmly rooted in our national consciousness that 100 years ago, a distinguished member of this court was able to proclaim, quote, "Man is or should be woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life." Some of you will recognize that language from the concurring opinion in Bradwell versus Illinois. Frontiero, therefore, marked a momentous departure from the precedent set by the Bradwell decision. Instead of protecting women, the court acknowledged that discriminatory laws also hurt them and prevented them from enjoying the same rights and privileges as men. The plurality opinion declared that courts must use strict scrutiny and treat women as a suspect class. It compared the status of women to that of slaves and acknowledged that sex discrimination was like discrimination on the basis of race or national origin. And yet it was only a plurality decision, not a full majority. Justices Brennan, Douglas, White, and Marshall voted to make women a suspect class. But a plurality decision does not create binding precedent. 4 other justices agreed that the Air Force's policy was unconstitutional, but they disagreed on the reason why. And 2 justices, Berger and Blackmun, joined with Justice Lewis Powell in a concurring opinion that shied away from declaring sex a suspect classification. So why did the Supreme Court decline to make women a suspect class, even as 8 of its justices agreed that sex discrimination could be unconstitutional? In short, because of the Equal Rights Amendment. Powell's concurring opinion agreed with the plurality that the policy violated the Fifth Amendment, which has a kind of implied equal protection clause, since this was a federal case, not a state case, and the 14th Amendment applies to states, but explicitly declined to make sex a suspect class. The results of the opinion, the opinion argued, were too broad and sweeping. The opinion states that, quote, "Democratic institutions are weakened, and confidence in the restraint of the court is impaired when we appear unnecessarily to decide sensitive issues of broad social and political importance at the very time that they are under consideration within the prescribed constitutional processes. In other words, the Equal Rights Amendment should do the work. It's clear that Powell, Berger, and Blackmun thought that the ERA was likely to pass, but we know that it did not, and to this day, sex discrimination is not treated by the courts as seriously as other forms of discrimination. The plurality opinion pushed sex discrimination law into uncharted waters. What kind of judicial review was appropriate for sex discrimination? Somewhere between rational basis and strict scrutiny was a new level of judicial review that the justices would fully articulate in a 1976 case that may be familiar to some of my audience members, Craig versus Boren. In this case, a male student at Oklahoma State University challenged a state law that allowed women to drink low-point beer in bars at age 18, but restricted men to drinking low-point beer in bars until age 21. The state of Oklahoma argued that the law was an important one that curbed drunk driving, though one could imagine that it also conveniently served to expand the dating pool for young men. But the Supreme Court disagreed. The Supreme Court disagreed that the law passed muster with the Equal Protection Clause. Instead, the Supreme Court articulated a new form of judicial review called intermediate scrutiny, which placed sex discrimination at a higher level than rational basis, but lower than strict scrutiny. To pass intermediate scrutiny, a law must serve an important government interest, not compelling, and be substantially related to achieving that interest. This is a much lower bar than the compelling interest, narrow tailoring, and least restrictive means required by strict scrutiny. Craig versus Boren continues to be precedent in American sex discrimination laws today. Reed, Frontiero, and Craig demonstrate how quickly American constitutional law was transformed between 1971 and 1976 when it came to sex discrimination. While they wiped out many older forms of discrimination and created a great leap forward for feminism, other battles have been fought piecemeal, like those for equal pay in the workplace or rights for pregnant women and employees. Without status as a protected class, since the 1970s, women have found more success in legislatures than in the courts when it comes to sex discrimination. But there's no doubt that without the efforts of Ruth Bader Ginsburg, the Women's Rights Project, and the plaintiffs in these cases, progress would have been much slower, and women would have struggled to receive the full benefits of American citizenship. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.